The Honourable David Parker.
Mr Chairman, I rise to both support the bill but also record my support for the submissions that have been made by earlier speakers as to process. I think it would have been desirable that this wasn't considered under urgency, and I think it would have been desirable that the changes that are proposed by SOP were done in some other way. The points have been well made by earlier speakers, and I won't add to that. Thank you.
The question is the Honourable David Cunliffe.
Chairman, I rise to take a short call on the Judicial Matters Bill. I wish to record Labour's support for the bill and its opposition to the SOPs. Sir, as the previous two speakers have noted, this bill is a bill which affects matters of a constitutional nature. It is largely above politics, and it is about the conduct of judicial behaviour. Sir, the important place of the Judicial Conduct Commissioner in our system is recorded, and the need for judicial conduct panels. Mr Speaker, the main provisions of the bill are to establish the new office of the Deputy Judicial Conduct Commissioner appointed by the Governor-General on the recommendation of the House of Representatives after the House has been advised by the Attorney-General. The Attorney-General, to do that, has to consult the Chief Justice on that recommendation. The function of the Deputy Commissioner is to carry out the functions of the Commissioner in relation to complaints during his or her absence from office or incapacity. And, of course, on occasion, the Commissioner has faced conflicts of interest, and if those arise, a Deputy will be able to step in. And so that's all in the name of ensuring that the conduct review process is quite clearly beyond reproach, as is appropriate, and I'm sure that the Attorney sitting in the chair would agree with that. Sir, the bill gives to the Commissioner a power to take no further action in respect of a complaint if it's satisfied that further consideration of that complaint would, in all the circumstances, be unjustified. That is a magnificent legal truism. Nonetheless, sir, it does speak to a point, which is that there needs to be the discretion on the part of the Commissioner to decline to deal further with complaints which might be, for example, of a vexatious or frivolous nature, complaints which are outside, in the Commissioner's views, the powers or role of the office of the Commissioner, and that's in addition to the three current powers to dismiss the complaint if it's vexatious, to pass the complaint on to a judge who's superior to the one subject to complaint, or to set up a special judicial conduct panel. And I guess it goes to the point that my colleague, the Honourable Leanne Dalzell, made, which is that we should not ignore the possibility that judges themselves can come under pressure. It's a difficult job. They receive variable submissions, of course, and they have to deal with a large number of clients, finding themselves in all sorts of different circumstances under some enormous time pressures, and from time to time they can show that pressure. I think it's also important for us to note that judges are human. Judges themselves bring to the courtroom their own perspectives, they reflect their own backgrounds, and from time to time, unusual as it is, those factors may cause a judge to demonstrate behaviours which might not in other circumstances be appropriate. It's also fair to say that a large number of our judges are male, and a large number of them are relatively senior in years. Most of them are Caucasian. Those factors all bring a certain inherent perspective, and it's important that we have processes which provide assurance to the public that no matter what the background or constitution of the judge, that they will be entitled to a fair hearing in law before the courts. And I think we would, across this House, be of the view that one of the great treasures of living in New Zealand is that we do have a legal system that by and large functions pretty well, and that does accord to New Zealanders the opportunity to have their business heard should they need to in a fair and just manner. And that's why, of course, we have things like legal aid, because it is important that justice is available for all, and that cases are decided primarily on the merit of the case, not the size of the wallet, and that access to justice reflects the constitutional rights of every citizen. This bill, sir, is one small way of further enhancing the process, of further buttressing the review mechanisms within the process to ensure that unfortunate biases or errors of behaviour can be dealt with. And as such, in general, the Labour Party supports it. There are a number of SOPs, notably SOP 108 and 109, that Labour will be voting against in this bill. And Mr. Chairman,
David Cunliffe,
if I might just take a moment to explain why we're doing that. Sir, according to the explanatory note, SOP 108 will give the Commissioner an added option after the preliminary examination to refer the complaint if substantiated to the head of bench under Section 17, and of course there are a number of consequential amendments that flow from that. It will increase from 140 to 156 the maximum number of district court judges. It will authorise higher duties allowances paid to High Court judges serving the Court of Appeal so that they rest on a more secure constitutional foundation. What a lovely turn of phrase.
Order. The substance of your speech is now related to new Part 1A. We're on Part 1.
Thank you, Mr. Chairman, for that clarification. I thought it appropriate to mention the overall position that the Labour Party was taking, but I take the guidance of the Chair that it's not appropriate in this part to go into the detail of those SOPs. May I merely recall the fact, sir, that the Labour Party is going to be opposing both SOP 108 and 109. Sir, in continuing, I would note that the Attorney General had a number of objections in the first reading. He said, and I quote, that the National Party approach is to do it subtly but do it effectively. And sir, I think that does bear remarking upon, perhaps more in its general context, that there is a very active debate going on in this country about whether the hallmark of the current government is subtlety or effectiveness, in the words of the Attorney. Now, those of the subtlety view, including many in the business community, sir, are of the view that the government is so subtle that it is almost impossible to discern the direction of travel. That has been one of the main responses of the commentariat to the Prime Minister's opening speech to the House, and certainly in the economic policy area, which is for a different debate than today. There's a great deal of concern in the business community about whether the government's intentions are clear enough and whether there's a coherent strategy that would allow the economy to expand and create jobs. And we, sir, are of the view that we would welcome further elucidation of the government's intentions in that sphere, because try as we might, we're not quite sure how the so-called pillars of change add up to a substantial positive impact on the economy. That's the subtlety school of thought. The effectiveness school of thought, which gives some members of the business community comfort, sir, is that the government really does have a significant plan for change up its sleeve, but it just hasn't or doesn't wish to yet tell New Zealanders what that is, because it might not be something that they would like. And the effectiveness school tends to the view that many of these things will be revealed in the second term of the government, if it were so fortunate as to get one, and that we might in the second term see the government showing, should that occur, a more, what would be a good judicial word, a more flagrant, and perhaps not, a more unmasked determination to deliver to core stakeholders, as they might put it. So I'm admittedly, sir, drawing a little bit of a tangential bow from the, as always, perspicacious semantic approach of the Attorney General, where he has nailed, sir, the National Party's approach to do it subtly but to do it effectively. And in so doing, in this one office holder, sir, I think the House would congratulate him for unifying these two strands of thought about the nature of this government. He's unified it in one sentence, and he said they're both right.
Well, he is,
my colleague has pointed out, really their philosophical icon. Was that the word? Oracle. He's gone beyond icon to oracle. No doubt we'll be addressing him as Sir Christopher Finlayson before long. No?
SC.
No. The Attorney General, I'm told, is a Republican, and for that reason